Let's speak now to Blind SA Chief Executive Officer Jace Nair. Very good evening to you, and thank you so much for speaking to us, Mr. Nair. Let's just first start with the Copyright Act of 1978. What exactly does it say, and what makes it unconstitutional for your community?
Thank you very much for this opportunity. Certainly, the 1978 Copyright Act is outdated, but more importantly, it does not provide any exceptions and limitations so that published works can be transcribed into Braille, into large print, or into DAISY or audio. So this then limits our access to information, to reading material, to educational material, etc. Only about 0.5% of published works in South Africa is available for blind people. And of this, majority of it is in English. There's very little in Afrikaans and virtually none in the African languages. So the current requirements makes us criminals if we had to reproduce these published works into accessible formats. We apply to publishers for permission. Some of them would grant you. Less than 10% have granted us permission to transcribe their books over the last 20 years. So the majority of them just ignore our calls for permission to have those books transcribed.
And what reasons are you given?
The quality of education.
Mr. Nair, what reasons are you given for those publishers that you do approach to reproduce the work? And ordinarily, how long does it take to convert the works into Braille and audio?
Like I said, 90% of the cases, we don't even get an acknowledgement or a response from publishers. Those that have given us permission have done so, and it could take anything up to 3 months to a few years for them to grant you that permission. For us to convert a book into Braille, for instance, we first have to retype that book, data type it, we have to proofread it, and we would have 2 people to proofread, a Braille reader as well as a print reader, to make sure that the text is correct. All these processes can take us anything up to 24 days to produce one 300-page book. It also then costs us approximately 24,000 Rand to print that book. Yet we are still expected to pay for the print version of that book in order for us to transcribe that into an accessible format.
Just in terms of what is availability to the blind and visually impaired community, of what percentage of publications are accessible to you?
As I indicated earlier, only about 0.5% of published works is available in accessible formats, and most of these have been produced by organizations like ourselves. And we find that for instance, if we take, there are 23 schools for the blind in the country currently, and only 50% of the textbooks that our learners are using in schools are available to them in Braille. So therefore, the quality of education is very limited for our learners. Educators, staff, and parents and others have to read text to blind and partially sighted children. So the need to have accessible formats is a fundamental right.
So if you want to publish a book, and I know you said that most of the time people don't respond to you, so if you wanted to publish your own material, what are the limitations? And this is beyond the economic cost that you would face.
I think maybe the response to that is if someone needs a book, a sighted person can walk into a bookshop or walk into a library, and you can either purchase that book off the shelf, or you can borrow the book of the library and get to your place of convenience, open it and read it. Now, for a blind person, we don't have that opportunity. If you walk into a bookstore, there are no books available in accessible formats. There are some audio books that are available. However, the audio controls for you to navigate that book is very difficult. You are unable to read the text itself on the audio book. So you're unable to spell a word, you're not able to read, particularly when it gives you names of cities and things like that. So similarly, we can't walk into a library and just borrow a book. So there is a need for an individual that requires a book to then check with an organization that can obtain permission to get that book produced, and thereafter make that book available for this person.
So I
Sometimes,
guess I'm
like I
just
said,
trying to understand the legal impediments. And as you say, specifically here we talk about the Copyright Act of 1978, so the reproduction. But I just want to understand, are you at least recognized in terms of making it easier to publish your own material as the blind or visually impaired community? Because you obviously have your own knowledge and things that you should say, literature that you would want to reproduce. Does that also make it an arduous task?
Absolutely, because the law does not allow us to reproduce a book unless we have the permission of the publisher. So if we produce a book, in terms of the law, my apologies, in terms of the law, we are then breaking copyright infringement. And for the first offense, you could be fined 5,000 rand. Or for the second offense, you could be fined 10,000 rand. So the Copyright Act makes us criminals because we're wanting to read published works. So we say Braille is no crime. End the book famine, so that we too can have access to published works in an accessible format that we are able to read in a format using screen reading software or using our fingers to read Braille.
So what are you asking for the courts? And I'm just also trying to figure out if there are broader terms that you're seeking beyond the Copyright Act, as in to ensure that even the material produced by blind people is easily accessible to other blind or visually impaired people, so that you won't have similar problems like you're experiencing now with the Copyright Act.
Firstly, what we are asking the Constitutional Court to do is to confirm the Gauteng High Court order given on the 21st of September last year that the current 1978 Copyright Act is unconstitutional since it limits exceptions and limitations for transcribing material into accessible formats like Braille, DAISY, and large print. We are then also asking the Constitutional Court to provide some remedy, some relief in an interim basis for 12 months, that the current Section 19D in the Copyright Amendment Bill, which is based on the principles of the Marrakesh International Treaty that allows for accessible formats to be produced, to be read into the Act, that does not make transcribing into Braille a crime in the country. That also that Parliament should be given 24 months so that they can produce a permanent solution by enacting the Copyright Amendment Bill, which would then have the provision of Section 19D that provides for accessibility, that provides for cross-border exchange, importation, and exportation of accessible published books. And it would allow for publishers to use born accessibility so that when they are designing publications, right at the outset, that they put in accessibility features into the software so that it would be easier for blind and partially sighted people using screen reading software or magnification software to read those publications.
Thank you so much for speaking to us and sharing with us the experiences of the blind and visually impaired. CEO of, or rather SA Chief Executive of Blind SA, Jace Nair.